The judge just referred you to the front of the court. You have a meeting scheduled, but nobody told you what the meeting actually is, or that you might be asked to settle your custody and parenting time order right there on the spot. Too many parents walk into those meetings unprepared. Some walk out with an agreement that they regret. Not necessarily because they made a bad decision, but they didn't know what was going to happen. They didn't know what their options were. By the end of this video, you'll know exactly what the front of the court meeting is, how to prepare for it, and how to decide whether or not you're going to settle during that meeting, and what happens if you don't. I'm Jim Kraayeveld, founding attorney at Kraayeveld Family Law here in West Michigan. Been doing this for over 3 decades. So let's talk about it. First, what is the front of the court meeting? Some counties call it a FIG conference, Financial Information Gathering Conference. In Kent County, it's just an investigation conference where they're initially going to meet with parties, and the intent is to see if the parties can reach an agreement and enter an order. If the parties can't reach an agreement, typically the front of the court will continue its investigation. They'll often send out a form, a questionnaire that has to be answered before meeting with the front of the court caseworker. It's often wise to have an attorney help you with that, because then you know what you should be providing or not be providing, and knowing how to approach the entire process. You're going there, and you should be prepared to go there with documentation to support your position, to know if you have witnesses that will support what you're going to say. And you also need to know, if you're prepared when you walk in, that you're not going there to fight. You're going there to show why you are fit and proper to have good parenting time, good custody of your children. That's what the investigator is going to be looking at, watching for. How do you conduct yourself in the meeting? How do you respond to questions? What evidence do you have? And all of that you put to them is super important, because they're going to be issuing a report and recommendation. If you're going to object to it because you can't reach a settlement at the meeting and you don't like what they recommend, you're going to have to know what happens next. And again, you're going to want to know if you should settle at the meeting. For example, they walk in and say the two of you agree to joint custody, joint equal parenting time. You think that that's appropriate for you, it's appropriate for your children, and they put that in front of you. Well, if that's what your goal was, sign it. But if it's not what you wanted and it's not what you're comfortable with, then you don't, and you ask them to continue with their investigation. But even then, you might not like the results. You have the right to object, and then you'll end up with a hearing in front of the court, and you're going to have a trial, whether it's partway through your case or if it gets adjourned and they make it as part of your entire custody trial. But then you're going to have your witnesses, your experts, your evidence. And again, to compile all of that and be ready for it, you need to have an attorney that knows what they're doing. You'll also have to know what the cost will be of pursuing that. If you're fighting about one overnight per month more, is it worth it? So, if you came here because you have a friend of the court meeting and you don't know what to expect, that's exactly why this channel exists. We cover Kent County procedure, Ottawa County procedure, Michigan custody law, and the specific situations that West Michigan parents actually face. Subscribe so that the next video is ready when you need it. 1 video a week. We tell you what Michigan courts actually do. And if you're in the middle of this right now, or you know that it's coming, the most useful thing you can do is have a conversation. You don't have to commit. You don't have to sign anything. But know your rights. Get a clear read on what the law is going to look at, what your options are, what it's going to cost. Our firm offers consultations. We respond within a day. Be glad to help you. Until next time.